Hi, Advocate Amrita. Am I audible?
Yes. Hello.
Hello. Hi, how are you?
Hi, hi. Great.
Good. We will start the session at 4, around 4.
Yeah. Yes.
Bhanvi? Hi, Anita. You're on mute, I guess.
Oh, sorry. Yeah.
How are you after long time, after a year?
I know but since we last met at Vadeshwar or wherever, no, after that.
Yeah, Deccan.
Deccan. Yeah. So
Yeah,
what's happening with your RICS
it's going on.
process now?
Yeah,
Okay.
it is under process.
Okay.
Actually, I'm in the process to get the third PhD. So
Oh
I
wow.
was.
My God, you are like too much. Yeah. How many?
Uh,
What
yeah,
is the subject? What will be the subject?
I will call you and tell you it's very interesting subject.
Yeah.
Yeah,
Okay.
yeah.
Okay. That'll be nice. Okay. So when are you likely to get that?
Everything is done from my side. A few changes have been done by the mentor, so it's
So
already given to him.
Which university are you doing it from?
It's again SSBM, Swiss School of Business Management.
Oh, from there only.
Yeah.
So online, they do long distance, is it?
No, it is not actually long distance. So
Ah,
I'm traveling to there, Geneva
uh-huh.
quarterly.
Oh, is it? You have to go
Yeah,
quarterly?
yeah.
Oh, okay. Interesting. Yeah, very nice. Acha, what happened about your Harvard thing? Did you get a chance to go?
No.
Acha, you didn't make a go.
No, I didn't make it.
Okay.
After this, I will try to. After
Yeah.
this, MRICS and then
My,
Harvard.
you have a lot of things lined up,
Yeah.
huh? Good. Very good. So I think just 1 minute she should be there.
Yeah. I'm just putting on the mute. I have
Yeah. I will also put it and remove the video also.
Bhanavi, we will start in 5 minutes.
रिटर्न गिफ्ट ठीक है कलर टी शर्ट पर है
Hello everyone.
Hi. Advocate Amruta, can we start?
Yes, we can start.
Yeah. Hi, good evening, everyone. It is my privilege to introduce a legal expert and pioneer in Real Estate Regulation Act 2016, Advocate Amruta. And her journey is a true testament to the belief that dreams can indeed come true with hard work and dedication. And we all are aware that real estate is the most significant industry, and the introduction of RERA Act has played a crucial role in bringing transparency and accountability to the real estate sector. And the Real Estate Act has been a game changer for both the developers and home buyers. So, recognizing the importance of this transformation, Advocate Amruta found her calling in this field and has been an active contributor in RERA. And starting her career in the corporate with the real estate firms like Poonawalla, Sobha, Brahma Corp. And however, later on, her passion led her to take a bold step in 2017, and she founded her own company, which is Gate Age. And today, her firm serves over 4,000 construction houses across Maharashtra and Goa. And under her leadership, the firm has successfully registered more than 2,000 building projects in Maharashtra and around 300 projects in Goa, ensuring the compliance with RERA regulation and which is helping the developers and customers. We are honored to have you here, Advocate Amruta.
Thank you.
And dear Mahi girls, please join me in welcoming Advocate Amruta Bhosle Salunke. Over to you, Advocate Amruta.
Thank you so much for giving me the opportunity. And as we all know, RERA Act is now more than 7 years old. And everyone knowing about RERA, and it is like this is the first act which is only for real estates. And this act particularly deals with developers and allottees, the problems between developers and allottees only. So this is the first act which is only for real estate and the problems between the buyers and the developers. So without taking time, we will start with the PPT and the session.
Please, please.
Yes. Yeah, my sharing tool is disabled. I think so.
Let me check.
Yeah.
Advocate Amruta, we can see your screen.
Yes.
Please proceed.
Yes. So I will start with the basic of real estate, which involve the more RERA into it right now. So the first part is the first part is land ownership. When we talk about real estate projects, we know that we have different types of deals with landowners, and the most important three parts are sale deed, joint development, and joint ventures. As we purchase the land sometimes, and then we registered sale deed with the landowners. Right now, RERA is given different rules for all these three types of land deeds. So in a sale deed, when we registered sale deed and we give total consideration to the landowner, then the project is not so difficult. And sale deed, we register the project uh, with the developer only. Then the second part comes here is joint development. So what we know about joint development is joint development where the developer gets the development rights, and he shares some part of project with the landowner. So there we need to register this project with different parts of it, and we give more information about the landowners. So the joint development is like where we share the area with the landowner. And the third part is joint venture, where we share revenue from each flat or from that particular project with the landowner against the land. So these are the basic important three types of projects what we do in real estate projects right now. So we'll go to the next part. Yes. Application for RERA number. We all know we have to apply for each and every project for RERA number, and we cannot advertise or we cannot sell the project without RERA number. So for application, we all know what are the basic documents we require. I will not go in that session, in that section. I will just I will just give the brief idea about what is new now for the RERA applications. So after getting sanction and commencement certificate from the concerned authority, we can apply for RERA number. Without sanction and without commencement certificate, we cannot go for RERA application. This is the basic and important document for RERA application. For this commencement certificate, when I say this commencement certificate includes the survey number and the address of that particular project. And that particular address is reflects on your RERA number. So nowadays, commencement certificate, we need to check in that particular document that the address of the property of the project should be correct address, and that same address will reflect on your RERA certificate. So this is important, and this is particularly what is checked by the RERA authority nowadays. For larger projects, when the project includes more than one building, we can phase out the project. We can register that particular project in many phases. Where one building we can register first, and with that particular building, we can add some of the amenities. Likewise, we can register larger project in many phases, and that is allowed by RERA and RERA Act. After that, after receiving RERA number only, we can do the advertisement. Any type of advertisement nowadays, we require RERA number to be mentioned on those advertisement. Any written, verbal, using any type of technology, when you advertise your project, you need to put the RERA number with the RERA website address and with the scanning code. So that is important. And now RERA, in MahaRERA particularly, they have separate section to check all the advertisement of the project. And nowadays they are sending notices to the developers if they miss anything from these. So these three things after RERA number, you have to mention in your advertisement, any type of advertisement. That is RERA number, scanning code, and RERA website address. These three things are compulsory and important in your advertisement. Then after advertisement, you can accept the bookings. I will just add here, after RERA number, all the projects, all the developers need to follow the payment schedules for bookings. For bookings, only 10% of the full consideration can be accepted by the developer. And the allottees also should need to pay only 10% of their total amount of that unit for bookings. After bookings, then the payment schedule comes in the picture, and then you need to register the particular units agreement within 30 days, and after registering the agreement, you can accept 20% of the consideration, and then the slabs comes in, and as per the construction slabs completion, you can accept the particular booking particular percentage of the total consideration of the units. This is now because of RERA Act, because of RERA Act, the payment stages are there in real estate market now, and the stages needs to be followed as given by RERA. Then we need to mention the completion date at the time of application of RERA number. So completion date, there is no limit given by RERA that you can mention 3 years or 10 years or less than 3 years to complete the project. This is upon the developer whatever completion date he wants to give, he can mention that particular completion date. And the developer needs to maintain that date and maintain the construction slabs according to that completion date. Only that whatever completion date the developer is giving, he need to follow that date and he need to complete the project on or before that given completion date. So for registration, I always suggest that give 6 months period, at least 6 months period to complete the project, and give 6 months grace period in your agreement also. Then comes the revision part. As we registered the project under RERA, and we all know that we were in so hurry to get the RERA number and start the project selling and advertisement. So we register the project on the basic FSI, whatever is sanctioned at the time of RERA application. Then we required many times we do the revisions in the sanction plan. So it is very necessary to disclose all your revisions and whatever the outcome at the time of possession, whatever the project you are going to deliver. So those revisions you need to mention in your agreements with allottees. The agreement what you are going to share registered with the allottees or future buyers, you need to disclose all your revisions, maximum, I can say maximum revisions in your agreement to sale. You can also disclose all your revisions at the time of RERA application also. You can give your future plan with architect's signature and a stamp at the time of application of RERA numbers, so that in future you don't require any consent from any allottees. So the expected revisions you need to mention and you need to disclose in the agreement, as well as you can disclose on the website also. When we discuss about the larger project where you register the project in phases, at that time the recent amendment or the recent circular that is passed by RERA, that when you registered your first phase in RERA, then after that you cannot change the specification and amenities in that particular layout. Specifications and amenities includes clubhouse, children play area, or transformer, then the swimming pool, and many, like whatever the additions you are giving in that project. The location of those amenities and specifications you cannot change or modify without consent of the existing allottees. So when you want to change the location of the swimming pool or clubhouse, you require more than 70% consent from your existing allottees. This is the important amendment what is there now under RERA. Now, as we know, there is a banking system given by RERA, and all the developers needs to follow that. And nowadays the allottees, the flat buyers also know that developer can use only the RERA account to take their money and deposit all the consideration in that particular account. Now the developers needs to give all three account number and the details in the agreement also. So the buyers also know that what are the accounts and where they are depositing the money or giving the consideration for the particular flat or unit. So this is, I will explain the banking system for the developers now. As we have seen that there are three types of projects: through sale deed, joint development, and joint venture. So in the joint development, we need to open 3 bank accounts. Joint development means where we are sharing the area, or we are giving some flats, some units to the landowner for the land and for the development rights what they have given against the land to the developer. So here we need to open, the developer need to open 3 bank accounts. First will be the collection account. The second is separate bank account, which is your RERA account. And the third is 30% transaction account. So RERA has given some guidelines how you can use these 3 accounts. So developer needs to deposit all the checks, whatever he is getting from the allottees or the flat buyers, he need to deposit the checks in their 100% collection account. Then the 70% funds will transfer to separate account, that is your RERA account. And all the project related expenses like construction estimations, then the payments to the consultants, payments to all the vendors, all those expenses he can do from 70% separate account. Then the third 30% transaction account. Transaction account is also now taken by RERA, and RERA is having full charge on these 3 accounts, where from 30% RERA authority can collect the penalty charges directly. So the 30% transaction account can be used for deposit, for doing your administrative charges or for any other charges which is not connected to the particular project. So 30% you can use the funds for any other project also. When I say joint development and area sharing, then some area of that particular project can be sold by the landowners also. For those units, the landowner is also now compulsory needs to open these 3 accounts. 100%, 70% and 30%. How to use those funds and how to withdraw those funds by the landowners, the guidelines are yet not given by any RERA authority. So the account opening process is only the compulsory part for the landowners right now under joint development. Then the joint venture. In joint venture, the revenue is shared by the landowner, as we have already discussed. So here some slight change is there. The developer and the landowner jointly needs to open 100% master account, where all the funds and all the checks from the buyers needs to get deposited. Then after master account, the funds will get divided as per the revenue sharing ratio. And then the funds will transfer to 70% and 30% of the landowner and the developer. So this is the slight change between joint development type projects and joint venture projects. So this is the new banking system what is RERA has introduced. As I explained about completion date of the project. So many times the developer needs extension for that particular completion date. And RERA is given 2 sections for that, for extension of that completion date. When whatever the reason may be, if the project is delayed by 1 year, then under section 6 developer can apply for extension, and for that particular extension of 1 year the developer don't require any consent from the allottees. Allottees means the flat buyers. So under section 6 you can get 1 year extension from RERA authority without asking any allottees. So that 1 year extension you can get only after the application of extension. Then comes where the project is delayed or going to be delayed for more than 2 years or more than 1 year, then that application comes under section 7(3), where RERA Act is given the liberty to apply for extension more than 1 year. For that particular application, the developer requires minimum 51% of consent from the existing allottees. From the existing allottees includes booking and agreement registrations also. So there are two types of allottees. When we take only booking amount as per RERA Act, those flat buyers or those booking is also considered as sale under RERA. And when we register the agreement, those flat buyers are also allottees according to RERA. So for extension under section 7(3), the developer needs to take consent more than 51% of consents from the existing allottees, the bookings and the agreements included in that 51%. Where we can see how many numbers of bookings we have already taken, or where the RERA authority can see that. So RERA authority knows how many bookings you have taken in that particular project through the chartered accountant certificate. And also we need to give the sold unsold inventory quarterly. In that inventory also, RERA authority can cross check that how many total bookings or how many total registrations are done under that particular project. When chartered accountant gives the certificate, he needs to mention how much money is deposited in the particular RERA account. So he needs to give the exact entries, how much amount is received against the booking and against the registered agreement. So there RERA authority can cross check that how many total number of bookings and how many total number of agreements are done under that particular project. So we need to check that what we have already disclosed on the website and how many consents we need to take for that particular extension application. Section 6 extension application is, I will say, easy application and RERA authority can give you the extension. But section 7(3) applications, you need to approach to the allottees and there the problems arises. So that particular application is very difficult. So that's why I mentioned that whenever you give the completion date in the particular project, you need to at least take 6 months leverage period to complete your project. Any problem arises in the project, so you are rest assured that you have at least 6 months more to complete the particular project. In the agreement, I will more extend the completion date here. In the allottees agreement, you give the completion date, and then there is a provision under RERA that you can give the force majeures also to extend that particular date. If you have any force majeure arising in your project, you can apply more than 1 year of extension under 7(6) only. So you can get the extension under the circumstances where force majeures are arise. Then in the agreement only, you can mention if you have given the completion date later and you are going to give the position earlier, so you can mention the early date in the allottees agreement. That is also possible. So for technical reasons, you can give at the time of application of RERA number, you can give the date later on so that you will not require to go for extension process. Yes. The important part of RERA is chartered accountants' involvement. Under RERA, the chartered accountants needs to give two certificates. The first is Form 3, which the chartered accountant needs to provide for every 3 months. That certificate includes your withdrawal capacity and withdrawal amount of funds. So particularly I have taken these two forms to discuss here because all the funds, whatever are there in your RERA account, you can withdraw only when the chartered accountant certified the incurred amount of the project. At the time of registration of the project, we need to give the estimations and the project cost of that particular project. And that though these costs we give in the Form 3 from the chartered accountant. So whatever is the percentage of estimation and incurred amount, you can withdraw from your RERA account. So quarterly Form 3 is required for QPR, that is quarterly progress report. We need to file under RERA, and that is the Form 3 what chartered accountant needs to give. If the particular developer use the funds before 3 months, then the chartered accountant can issue the Form 3 multiple times also. The banks always check your Form 3, that is CA certificate, before you withdraw any amount from the RERA account. So this Form 3 and the proportion of estimated cost and the incurred cost means the expenses whatever done that on that particular date. These amounts checked by the banks, and then only the banks allow you to withdraw that much incurred amount from your particular RERA account. Then the Form 5. This Form 5 is issued by chartered accountant on yearly basis. This Form 5 is particularly audit report, where chartered accountant mentioned that in this year this much amount is received under this project and this much amount is withdrawn from the particular RERA account. So this is the Form 3 and Form 5, which is issued by chartered accountant. In RERA registered project, the Form 3 is draft like that if your construction is going continuously and you are doing the expenses for the project regularly, then your funds never get blocked in the RERA account. And the certificate is drafted likewise that your funds will never get stuck under RERA account. So registering the project under RERA and issuing and opening the bank accounts under RERA is not that your funds or developers' funds will get stuck because of RERA banking system, because this particular Form 3 is drafted likewise that the funds will never get stuck if you are doing the construction on time and as per the slabs you are given to the allottees. So this is the importance of chartered accountant and the involvement of chartered accountant under RERA. Yes. Then RERA is also given some criteria for delay in the project and how the developers needs to act for that delay. Or the allottees also have some rights under RERA and they can ask for refund or compensation for the delay. So As per Act, RERA is given 3 types of delay and the compensation. First, we can see allottees can ask for refund and return the amount if the allottee is going to cancel the unit. If the allottee is going to cancel the unit, he can ask for refund. And we all know that RERA have given the interest payable percentage, and if the particular allottee is asking for cancellation, then the developer needs to refund the money with the interest whatever is calculated on the given amount. If the allottee files any complaints for refund in cancellation cases, then the authority can give order for additional compensation also. So if any allottee going for cancellation, you can give the refund within 30 days and you have to pay the interest whatever is calculated on that paid amount. Then the second situation is when the project is delayed and the allottee is asking for any interest or compensation. Then, and the case is filed under RERA Act. Then the developer have to give the compensation and the interest also. When RERA was introduced, that time some orders are passed by the RERA authorities and the rent was also allowed at that time. Means if the project is delayed and the allottee is living in rented premises, then the actual rent, whatever the allottee have paid, that rent refund was also allowed by the authority. But now when the act is very much clear and nothing about the rent is written in the act, so these types of orders are not now passed by any authority. But the authority can pass order for delay possession interest and the compensation also. The third situation for delay is any litigation arises on the project land. Then also the project can get delayed. In that situation, the developer is liable to pay compensation to the allottee. If any allottee files a complaint against the developer and the developer is facing any type of litigation, then also the developer is liable to pay the compensation to the allottee. As we know, the developer is having duties under RERA Act. Likewise, the allottees are also have rights and duties under RERA Act. I have not taken the developer's duties here because I assume that we all know what are the duties of the developer, and the basic and most important duty is to deliver the possession on time. That is the only important duty of the promoter right now. Likewise, the allottees are also have rights and duties. So the first part is the allottee can ask you documents related to the project. So most of the documents are there on the website, but some documents which are not there, those documents can be asked by the allottee, and it's their right. They can ask for the documents and the developer needs to provide the documents to that allottee. This is the duty of the developer to provide all the documents related to that particular project to the allottee. Then the allottee have duty to pay the demands, whatever demands the developer is asking as per the construction stages. Of course, those demands needs to pay off by the allottees on particular period which is mentioned in the demand letter. I will add here, as per RERA Act, the developer needs to ask for payments according to completion of construction stage. If the allottee is not paying you the demanded amount, then according to RERA Act, you can send 3 demand letters to the allottees, and if he bounce 3 demands of that particular completion stage, then you can send 15 days of termination notice, and directly you can file complaint against that particular allottee, and the booking or the agreement will get cancelled through the order of authority. This is the important provision what the developer have, and developer can terminate the agreement on their own if the allottee is not paying on time. Then the allottee can ask you the possession on the given date. This is the important right of the allottee. Then liable to pay the delay payment interest. If the allottee is paying you and delaying the payment, then the developer is having right to ask for the delay payment interest, where RERA is given powers to the allottees that they can ask for delay possession interest. The RERA Act is also given the powers to the developers that developer can legally ask for delay payment interest. Then the right of the allottee is to get the society form, and the duty is to participate in the formation of society. Then to take the possession on time. This is the duty of the allottee. Sometimes actually this particular duty is written here because some allottees do this, that the developer inform them that the project is completed and you can come to take the possession, and at that time the allottee needs to pay off everything. There are some cases where we can see that the allottee is not come on time and pays the final payment amount, final possession amount on time, and to avoid that final payment, they don't take the possession on time. So for this also, the developer can file complaint that the allottee is not taking possession on time, and you can go for cancellation and you can file complaint for cancellation. Then the duty of allottee is to participate in conveyance registration. After society formation, the developers need to give the conveyance deed draft to the allottees, and they need to participate in checking the draft and registering the draft. This is their duty. Complaint filing process under RERA. We all know that many allottees, many people now filing complaints under the developers, and they are. We heard that the allottees are harassing the developer and asking any percentage of interest, anything under RERA, and they are filing the cases under RERA. Whatever they want, they can ask for it. So this is not the case actually. The process of complaint filing is not that easy nowadays. They need to give the exact reason why they are filing the complaint. They need to give the evidences, they need to give the documents while filing the complaint, and then only they can file the complaint under RERA Act. And we have many times we have seen that where the complaint is not having any basis and the complaint is filed against builder only to harass the builder or to uh, get some concession in the final payment, then those complaints we can see that many those types of complaints are now dismissed by RERA authority. So the first point is any person having interest in the project can file the complaint. This is very important part that RERA Act is having, that any person having interest in the project means no one else who is not having any interest, not paid any single penny can file complaint against the builder under RERA. Only those people who are having interest in the project, who have booked the project, booked the flat in the project, booked the unit in the project, those people can only file complaint under this act. After filing the complaint, the process of complaint is the date is given by authority and we need to argue the matter. We need to file all the evidences, all the documents in soft copy on the website, and then the matter ordered by the authority. After getting order from the authority, the aggrieved person have 60 days to file appeal with the appellate tribunal of RERA. The RERA is having the authority part also, and the second appeal goes to appellate tribunal, which is run by RERA authority only, and the appellate tribunal consists judges of high courts. So after 60 days of the order, the aggrieved person can file appeal for the given for the order given by authority. If the problem is not solved by the appellate tribunal, then the appeal is directly to the High Court. The aggrieved person can file appeal in the High Court. So this is the process of filing complaint and the appellate tribunal also. Thank you so much for giving time. If anyone have any questions, they can ask for it.
Such an informative session, Advocate Amruta.
Thank you. Just a minute, I'll stop the sharing.
If anyone from the audience has a question for Advocate Amruta, please feel free to ask in the chat box.
RERA.
Hello, Advocate Amruta.
Hello, madam.
I just want to ask you if suppose the client has booked a flat in any project and due to any circumstances, if suppose the allotment letter is delayed by the developer and before that the client understands that he is not able to continue the booking. So in such a case, can we deduct the penalty amount from his booking amount?
Yes, of course. RERA is given the draft and the guidelines to cancel these types of units where the agreement is not there, and if you don't have the allotment letter also. If if the particular allottee informs you uh, before 15 days, then you can deduct some percentage. The slabs are also given by RERA. So yes, there are guidelines and you can deduct the amount from the paid
Okay.
amount. Yes.
Okay. Thank you. Thank you.
Thank you.
Hello, Advocate Amruta. I have a
Hello,
question.
ma'am.
Yeah, I have a question for you. How stringent are these rules in the sense that you cannot advertise or start booking without getting a RERA number? Because I have seen myself, I've seen cases where builders have not only advertised, may not have advertised very actively, but they are by maybe by word of mouth or small hoardings, and they are taking bookings for those people who are willing to book without a RERA number, because they show them the approval, the commencement certificate, and they say that RERA number, we are in the process of getting the RERA number, and people do book in such cases. Sometimes they also say that in case we don't get the RERA number, we will return your booking, or whatever the case may be.
Hmm.
And recently, one of my builders said that, "No, no, we'll start the booking. What at the best, what they will charge us a penalty. We'll pay penalty to RERA for advertising and booking without getting a RERA number." So, how
Yes.
stringent are these rules? Can you tell me?
Ma'am, the RERA authority now have the department to judge all these advertisements. So if the builder is lucky, the advertisement is not got by RERA authority. So that is still going on. But if RERA caught this and this practices continuously that particular developer is doing, then the RERA authority have the right to revoke those projects, and they can blacklist the developers. There are one or two cases that they have blacklisted the developer.
No, but is there a provision for getting away by paying a penalty? I mean, not getting away for good. I mean, few months, 1 month, 2 months, by paying some penalty. I mean, on above board, on paper.
Ma'am, the minimum penalty is 50,000 for one advertisement.
Oh, okay.
So some developers feel that this is the reasonable risk they can take.
Okay, okay.
They do that, but
Uh-huh.
this is against the act, and some people are also ready to book the units before RERA numbers. So
Right,
this is the actual practice what is going on.
right, right, right. Thank you. Thank you.
Thank you.
Advocate Amruta, we have a question from Orpita Das.
Yeah.
So I will read the question for you. So
Yeah.
if you can little bit elaborate about joint development, as I'm not finding the exact difference between JD and JV.
Yeah, JD means joint development where the developer is sharing area with the landowner for the development rights. And the JV is where the developer is sharing revenue with the landowner against the development right. This is the exact difference between JD and JV.
Thank you. Thank you for the answer.
Thank you.
I have a question for you.
Yes.
So you have worked in Maharashtra and Goa as well. So have you observed any gap in RERA implementation across Maharashtra and Goa?
Maharashtra is very strict about RERA norms, and Goa is developing right.
Okay, okay.
Yeah. Yeah,
I have a question from Hitesh. Are MAHARERA regulations superseding all previous regulations like MOFA or both apply?
yes, MAHARERA means the RERA Act is superseding the MOFA, and now where similar sections are there in MOFA and RERA, if the complaint is filed under RERA, then RERA authority is considering MOFA Act, but RERA supersedes MOFA, and both are applicable right now. No act is repealed because of RERA. Only the Housing Act is repealed by RERA Act. Otherwise, MOFA is also in existence.
Thank you. Thank you, Advocate Amruta. I have one more question for you.
Yes.
So, being in the real estate organizations, So I feel that there are so many challenges developers are facing while registering the RERA.
Yes.
So how can they overcome from the hurdles?
In 2017, when RERA registrations are started, at that time, RERA authority was not that strict. But now, as the act has also developed so much, the RERA authority is very strict about the applications. So, whatever applications the drafts are given by RERA authority, we need to thoroughly check those drafts. We need to provide all the informations, all the requirement whatever is given by through the circulars by authorities, we need to check that also. And the applications are should be done correctly, so that you no need to go through any queries or any questions asked by RERA authority.
Okay, okay. Thank you. Thank you so much. Anyone has any questions? There are no questions in the chat box. I would request Miss Anita to deliver the thank you note on behalf of all Mahi girls.
Sure, would be a
Smita ma'am,
pleasure.
you want to say something?
No, that's fine. I just wanted to say thanks to Advocate Amruta for sparing time for us. It was a wonderful session, and it
Pleasure,
was
ma'am.
insightful, and it will definitely help us. And we will need few more sessions like this. So we
Yes,
will trouble you again and again.
yes, of
Yes.
course.
Over to you, Miss Anita.
Yes, thank you, Ketki. Yeah, Advocate Amruta, it's been such an insightful session, and thank you so much for sharing this with us. First of all, it was so nice to see a young and dynamic lady advocate, RERA advocate, which was and with so much experience, having consulted so many developers, and you took us so easily. You took us through the various steps of registration, right through the registration up to the complaints, including the banking, which was something new to me, because I didn't have so much knowledge about that. And it was very good to hear about the 30% account, so that that the developers can pay their penalty through that, which is good to know. And also it shows that this helps to build trust with the builders, with the developers, because the finances are so tightly controlled by RERA, that it is so good to know that it takes care of the consumers as well as the builders, developers both.
Yes.
So thank you so much for this, and we look forward to having more sessions from you. And whenever we have any queries, we are going to trouble you for this.
Yes, of course, ma'am.
Thank you so much. Wonderful for all the Mahi girls here. Thank you so much on their behalf. Thank you.
Thank you, ma'am. Thank you so
Thank
much.
you. Thank you so
Thank
much.
you.
Thank you, Smita ma'am. Thank you, Ananta ma'am.
Thanks a
Congratulations
lot.
you. Keep
Thank-
going, girls. You're all so bright and brilliant. I'm so happy we started the Mahi Talks 3 years back. You girls taken it to the next level. God bless.
Thank you.
Thank you, Ananta ma'am.